Met. I'm Jackie Lipton. I'm the co-director of the Law Technology and the Arts Centre and the associate director of the Cox International Law Centre here at the law school. One of my real pleasures in this role is organising the Case Abroad at Home program, which is a program where every year this week, the week before the semester starts, we invite 3 international visiting professors to come and teach mini courses, intensive courses to our upper level students. And today's speaker is one of those professors. We always have one visitor from Canada, largely in honour of our Canada-US Law Institute, and Dan Uzzo is here from that institute. And we also have another of our Case Abroad at Home presenters up the back, Professor Linda Gao from Fudan University in China, and it's delightful to have her here. But it's my pleasure today to introduce the public lecture by our other visiting professor, Mira Sundara Rajan. She holds a Canada Research Chair in Intellectual Property Law at the University of British Columbia in Vancouver, which is an absolutely beautiful setting, but they've just demolished the law building to build a new one, so she's kind of homeless at the moment. I think she's very happy to have an office here. She might not leave at the end of the week, I don't know. She has a DPhil from Oxford in intellectual property issues. She is the author of the 2006 book Copyright and Creative Freedom, a study of post-socialist law and reform. She's also developing and editing a book on Eastern European intellectual property law, and the topic of her talk today is based around a third book that she's been working on that's coming out next year, I believe, 2010, and that book is entitled Moral Rights and New Technology, and that will be published by Oxford University Press next year. So without further ado, I'll hand it over to Professor Sundara Rajan.
Thank you very much, Jackie, and very grateful to Jackie for the invitation to come back to Case. This is my second visit here, and tremendously enjoyed my first visit, and the second one is shaping up to be even more pleasant. I have things here that I don't have at home anymore, such as an office and access to photocopying and prosaic things like that, but they do make a difference, so there you go. So the presentation today is about moral rights, entitled Moral Rights, the Future of Copyright Law. And as Jackie did mention, it's the subject of a book on which I'm currently working. And I'm particularly excited about this seminar because it's really the first occasion that I've had to talk about this work in public. So I hope you find it as stimulating as I do. So, moral rights, a mysterious and controversial area of copyright law. And I have so much to tell you about this area that we could spend the rest of the evening here. But rather than do that, I'll try to confine my remarks within the time available to the items that I've indicated in the outline here. So I'll start with a brief and practical definition of moral rights, move on to talk about the moral rights landscape in the United States with reference to 2 benchmarks, the Shostakovich Case of 1948 and the Daystar Case of 2003. I'll then go on to describe the international approach to moral rights in the Berne Convention for the Protection of Literary and Artistic Works, which is the main international convention for the protection of copyright law. And I will then go on to talk about the global approach to moral rights. In particular, I'm going to take an example case from each of the jurisdictions that I've identified here, the UK, Canada, India, and Russia, to show you how this doctrine has made its way around the world and how courts in different cultural and legal contexts interpret this interesting area of the law. Chances are we will run short of time, and if that happens, I will probably leave out the section on Russia, but feel free to ask about it in the time that's allotted for questions. And finally, conclude with a few words on why I think moral rights will have an important future right at the heart of copyright law and reform in the digital era. The theory behind moral rights is actually very simple. Is everyone able to see the lettering mostly. Can we do anything to turn off a light or something up by the slides, maybe? Some of us have better eyesight than others, perhaps. Okay, well, I'll be telling you about it anyway. So the graphic is really actually the most important part of this chart. So as I was saying, moral rights, it's actually a very simple theory. It's the idea that authors not only have a commercial interest in their work, but they also have non-commercial interests arising out of their creative activity. Now, when we classify a work as a copyright work, a number of different rights arise. Rights to restrict publication of that work by other people, to restrict the making of copies, the making of derivative works, and so on and so forth. So although we use a monolithic term, copyright, there's actually a great diversity of rights that can be included under that umbrella. Now, fortunately for us, most of those rights, the vast majority, fall into two major groups, the economic rights and the moral rights, just as illustrated in this small flowchart. And under the section on moral rights, I've indicated what are some of the main rights involved when we discuss moral rights and use that terminology. There are two major rights, a right of attribution, which of course is the right to have your own work attributed to you by name, and secondly, a right of integrity, which is a right to protect your work from harm. And I mentioned parody in the third little box, which you may not be able to read, because that's an area where a balancing of rights is involved, moral rights of the author versus the economic and moral rights of the person who makes the parody. So that's a very stimulating, interesting area of balancing of rights in relation to moral rights. Of course, there are many other rights which could be possible. For example, if we take France, France is always a good country to look at when we talk about moral rights because it is the country where the idea of moral rights originated, and it continues to have the most extensive scheme for the protection of moral rights in the copyright law of any country in the world. Rights in France include a right of disclosure or first publication. They also include a right to withdraw your work from public circulation for various reasons. For example, if your views have changed since you first published the work. So they have a number of rights beyond the basic platform of attribution and integrity, which I've identified as a major component of moral rights. So historically, as you can see, the doctrine of moral rights is associated with France and indeed with other civil law countries. Pretty much all of the countries of continental Europe have their own approach to the treatment of moral rights of authors. And in the laws of all of those countries, moral rights are a centerpiece of copyright protection. In the common law countries, of course, the situation is quite different. We are relative newcomers to moral rights, and we do tend to experience this doctrine as an area of controversy in our law. And that applies universally to all common law countries, the United States, the United Kingdom, Canada, Australia, and if we want to go a little bit further afoot, to India and some of the other former colonies as well, as you will see when I get a little bit further into this presentation. Let me not forget to mention New Zealand as well. The interesting thing is that in spite of the fact that we as common law lawyers tend to see this area as quite controversial, it is probably the aspect of copyright that is most widely recognized around the world. So almost every country outside of the common law sphere has not only some protection for moral rights, but a certain focus on it in their copyright legislation. And I think that in the era of digital technology, we're going to see a shift in the copyright laws of the world towards more recognition for moral rights. So the objectives of this talk today are quite simple. I want to begin by examining the status of moral rights and moral interests in the United States. I want to show why I think these interests are particularly important in the digital era. And then I want to go on, as I said, to consider how moral rights are protected in some representative jurisdictions of the world. And one of the interesting things that I hope you'll see as I get into that discussion is how this legal concept of moral rights is actually amazingly malleable and it takes on different characteristics depending on the cultural and technological environment where it comes into play. In the United States, actually, the concept of moral rights has been known for a very long time, at least since 1948, when there was a major case on the issue in New York State, the Shostakovich Case. This is a classic case in moral rights jurisprudence, and it involved the music by a number of prominent composers from the then Soviet Union in an anti-Soviet film called The Iron Curtain. And fortunately, there is a Canadian connection here as well, because the film actually had to do with the activities of Soviet spies in Canada. The case was brought in the United States by the Soviet government, and the Soviet government wanted to suppress the film on the grounds that the moral rights of the composers had been violated by the association of their music with the political views in the film. Now, in the case, an American judge found himself in this interesting position of exploring the idea that moral rights might be a part of American law. And he did this in good faith. He considered the possibility that the composer's moral right of integrity had been violated. When we read the judgment, there is a very striking recognition that in certain cases, here in the United States, there will be a violation of moral rights. And it's very interesting. He identifies two particular situations where that might happen. The first being in circumstances where there is a direct mistreatment of the work, so there's an intervention in the work that causes harm or damage. And secondly, very interesting indeed, that for the purpose of protecting works which are in the public domain, there may actually be a relevance and a need to recognize moral rights. So he seems to view the right as a way potentially of protecting valuable cultural heritage. But the judge then goes on to note that there are several practical difficulties with recognizing moral rights in the United States, indeed. And the first point that he raises has to do with the standard to be applied. And in his words, he asks, is the standard to be good taste, artistic worth, political beliefs, moral concepts, or what is it to be? So it's a very fluid concept. Second point the judge raises, he says it's going to be difficult to decide how to balance the moral right of the author against the rights of other members of society. And thirdly, he's concerned about the difficulty of finding appropriate remedies within the terms of US law. So if I can summarize, back in the time of Shostakovich, 1948, there were three obstacles to US moral rights. The first, clearly, was that no codification of any moral rights existed. So accordingly, secondly, if such a right were to be recognized, it would be so vague that it would cause troublesome uncertainties. Okay, for example, how could we prove a violation of the right of integrity? What kinds of evidence would be required? Would the burden of proof fall on the plaintiff or the defendant in such a case? And what standard of proof would we be expected to apply? Thirdly, the integrity right as it was recognized in worldwide jurisprudence meant something specific, as the judge noted in the Shostakovich case. It meant that the work itself had to be modified, touched in some way before the integrity principle could be invoked. The association of a work with discordant political views was not enough in itself to qualify as a violation of the right of integrity. And an interesting footnote to this case, the very same issue was brought before the courts in France, the very same case, and in the French courts, the plaintiffs won. It's a loss in the United States, a win in France. So you can see that the facts of the case are rather unattractive, but in spite of that, the idea of the right of integrity as a presence in American law did receive a fair and very interesting consideration by the judge. Now I think we need to revisit the ruling in Shostakovich because of a number of changes in the legal framework surrounding the moral rights of authors. In particular, the United States has now joined the Berne Convention for the Protection of Literary and Artistic Works. And of course, this is an event of enormous magnitude in the world of copyright. It signified full-fledged American membership in the international copyright system and a real opportunity for American leadership within that system, which had really never existed before. And the Berne Convention requires that member countries protect the moral rights of its authors. Accordingly, the United States has now become concerned with implementing this commitment in American law. And there are at least 3 possible methods of doing so, of satisfying that commitment. First one would be a general reform of the US Copyright Act to include moral rights protection. And from a lawyer's point of view, this would be the neatest solution of all, the most straightforward choice. But it's an option that hasn't really been pursued to date in the US, as many of you are no doubt already aware. Rather, it's option 2 that has had a presence, the possibility of passing special legislation dealing with moral rights. In particular, this has led to the adoption of the Visual Artists' Rights Act as part of US copyright law, an act which, as its name suggests, protects moral rights only in very restricted circumstances for the artists who create works of visual art. Third possibility, of course, is to see the development of the moral rights idea as part of US law through the interpretation of courts, so through the development of case precedent. And this point deserves some attention, because post-Berne, this principle has arisen in the case law on a fairly regular basis. But it has met with only limited success. And the Daystar case from the US Supreme Court, a 2003 case, really seems to set some limits on how far the development of case precedent can proceed within the terms of US membership in the Berne Convention. So what happened in Daystar was an attempt to apply Section 43A of the Lanham Act to a dispute. And the dispute concerned the failure to attribute moral rights to the original creators of a television program about World War II. And in fact, it's quite interesting because there were 2 potential moral rights claims here. There was a moral right associated with the makers of the original television program, and there was also a moral right associated with the author of the book, which was behind that first program. The author of that book happened to be General Eisenhower, as he then was. The case is interesting from a legal point of view because on the face of it, the Lanham Act doesn't have a lot to do with moral rights. Of course, it's a provision that deals with false advertising. But the analogy between a false designation of origin and a moral right of attribution is quite a striking one. And there was actually an earlier precedent in US law for the success of this particular argument, applying the Lanham Act to a moral rights concern. And that was the Monty Python case, which involved the rebroadcast of Monty Python skits with all of the naughty bits removed. And the Python members felt that that violated their rights of integrity, and they succeeded in pursuing that illegally in the United States. But in contrast, the Daystar case failed. And there were 2 reasons for the failure. The first being the fact that there was a multiplicity of authors who could potentially be treated as points of origin or originators of the work in question. And secondly, the fact that the original work had fallen into the public domain. And of course, by convention under US copyright law, access to the public domain is a very foundation of the law here. Okay, it's supposed to be practically unrestricted. In subsequent interpretation, something interesting has happened as well. The application of this ruling has been enlarged in some significant ways. It has come to apply to works which are still within the copyright term. So it's no longer a ruling about the public domain only, it's also a ruling about works that are still under copyright protection. And it's also presumed to mean that the difficulty of finding a proper origin of a work is effectively insurmountable, thereby invalidating all potential moral rights claims under the Lanham Act. Now, I think that the reasoning of the US Supreme Court in this case raises some questions. The first is fairly straightforward. Is it really proper to treat works in the public domain and works within the term of copyright protection in the same way? The second issue is a little bit more complicated and has to go back to my comments regarding who would be the proper moral rights claimant in this situation. Moral rights theory generally requires that the original author of the work be the claimant, and that original author must be a human person. So a corporation, normally speaking, can almost never make a moral rights claim. This rule does have some exceptions, but they occur in very specific cultural and legal circumstances. For example, Japan actually does have a provision that allows corporations to make a moral rights claim. But I think that that has to be understood in the context of a very different corporate culture from what we know in North America, or Europe for that matter. So here in the Daystar case, we have these, once again, very awkward facts. It's a claim by a corporation for moral rights, and in fact, the corporation that's making the claim is not even the corporation that's responsible for the original work. So very unattractive facts on which to test a moral rights principle in the United States. And I think that the justice's intuition in this case that this is the wrong claimant is probably a correct intuition. But it doesn't necessarily mean that there is no possible rightful claimant, that no one is in a position to be able to make a successful moral rights claim in situations like these. And finally, it's important to keep an eye on the novelty of the claim in question. So again, I think the Supreme Court has the right idea here when it seeks to determine the appropriateness of applying a statutory provision on false advertising to protect the moral right of attribution in a work. But this brings us full circle. What is the alternative under US law? And this really highlights the key difference between the era of the Shostakovich case and the present. When Shostakovich came around, the United States did not have any obligations in relation to moral rights under international copyright law. Now it does. So international obligations are an important reason why the US legal community needs to be interested in moral rights. I will go on to say, it's not just a question of fulfilling international obligations under US law. There's also another question here, which goes back to the title of my book, Moral Rights and New Technology. So there's an issue here about the United States being the leading country in the world when it comes to the digital revolution and digital technology. We have seen the impact of technology on economic copyright through phenomena such as music downloading, film and software piracy, and so on and so forth. But the moral rights issues involved in new technological phenomena have not really been discussed at all, very minimally. In fact, I think what we are going to find is that moral rights are very important in a digital environment for social reasons. So what happens when a work is digitized? Well, we can intervene in that work. In fact, anyone can intervene in it, usually without our knowledge. We can remove things, we can change words, we can insert or remove images, we can change, remove, or add the name of an author. There's so much that we can do to intervene in works. And when these things happen on a fairly large scale, the impact on society could be tremendous. It could cause the corruption of information and knowledge, potentially damage to the integrity of our cultural heritage, the destruction of historical truth. These are likely to become major social issues in a digital environment, even if we haven't yet recognized them or confronted them fully. And moral rights of authors are an important legal instrument for the prevention of some of these problems. Now, given the need for improved recognition of moral rights in the United States, one of the important sources of knowledge available to the US legal community is to consider some of the ways in which moral rights have migrated to different countries and how the doctrine has been received by them. As well, how the doctrine itself is able to adapt to different cultural environments. So I'd like to go on now to consider our international benchmark before we take off on our miniature global odyssey, and consider what the Berne Convention actually tells us about the international baseline requirements in the area of moral rights. Now, the Berne Convention is a classic formulation on moral rights. And when we deal with moral rights in different countries, we don't invoke Berne directly, usually, but it does provide us with guidelines about what legislation on moral rights is supposed to do in the member countries of the Berne Union. And another important point to note, because it wasn't always the case, is that now practically every country in the world is a member of the Berne Convention, the Berne Union. Okay, there was a time when not only the United States, but most of the Eastern Bloc countries were not members. Developing countries had questions about their involvement, and so on and so forth. This period of time in the history of Berne is different. It's a time when Berne has really become very well established in the international community. This is more text than I normally like to put on a PowerPoint, but I'll walk you through it very quickly because there's really no other way to communicate what's in the convention, masterful piece of drafting as it is. So 4 points to note about the Berne Convention provision on moral rights, which I've underlined. The first, this provision on the independence of authors' economic and moral rights. That's a key provision because what it means is that even after you have physically parted with a work, or after you've parted with the economic copyright in a work, a moral right continues to persist, and you as the creator continue to hold that right. So it creates an interesting legal anomaly between ownership and the control of a moral right. That's what independence means. Secondly, notice that the right of authorship is identified, so there is a right of attribution that is identified by Berne. We also have a right of integrity, a right to protect the work, to object, as they say, to any distortion, mutilation, or other modification of or other derogatory action in relation to the work. And fourth, notice the clause at the very end of that provision. You can only object to these acts if they would be prejudicial to your honor or reputation. So this is a very important limitation. It means that you as the author bear the burden of proof in a claim for the protection of your moral rights. And it might be difficult to satisfy that particular burden of proof because you need to know what kind of proof you have to offer and how persuasive it's going to be. So, for example, in Canada, the acceptance of expert opinion by the courts is an important principle, firmly ensconced as a result of the one successful litigation on moral rights that we've had in the past 80 years. Economic damage is another factor that is widely accepted in common law countries. I should also mention that this provision may mean that destruction of a work is not a violation of the right of integrity. Although that argument might seem counterintuitive at first glance, the reason is that destruction is said not to affect the reputation of the author. It destroys the work. There is no damaged work there to affect the author's reputation negatively. And I'll come back to that when I talk about the Indian case, because Indian judges are very hostile to that particular view of the right of integrity. They think that destruction should be covered by that right. Second part of the Berne Convention, sorry, it goes on. I did leave out the third part. But this part is important because it has to do with the duration of rights. So what it tells us is that the rights last at least as long as the economic rights, so at least until the expiry of the economic rights. And there is a provision here which says that if your country doesn't have moral rights legislation when you join Berne, you can stop the protection of some of those rights early. That provision, introduced in 1967, I believe, actually was specifically intended to accommodate common law countries, and the claim that most of our countries make that our tort law protections effectively cover the moral rights interests of authors. I should mention that because the Berne Convention only provides a minimum standard of protection, it's possible to have a longer duration of protection for moral rights, and many countries do. France, for example, protects moral rights forever. And that might seem to be something of academic interest, but actually it has very practical implications. The latest case on moral rights from France from 2007 was actually brought by the great-great-grandson of Victor Hugo. And the case had to do with someone who had written a sequel to Les Misérables, essentially reviving a character who had plunged off a bridge at the end of the original novel and proceeding to create a new story around those characters. It's an extremely interesting case because at first hearing, the French court upheld the claim of the great-great-grandson, all the more so because Victor Hugo, during his own lifetime, had asserted his dislike of the idea of any sequels to his work. He said the work is complete, it's a complete statement, nothing should follow after. And when the French court agreed with that perspective, it was taking a very traditional French approach to moral rights, where the acceptance of the author's point of view, a subjective approach, is favored. Now, interestingly, the case went on to appeal, and that ruling was actually overturned by the Cour de Cassation of Paris. And that court came up with a very common law style argument. It said, well, sure, Victor Hugo objected and this and that and the other thing, but actually, if we're going to allow this claim to succeed, we are seriously limiting the creativity of that new author who has made a work of value out of those existing characters and has a new copyright in his own right in that new work. And so the ruling was overturned on those grounds. Some French commentators support it. Some French commentators are strongly critical because it does represent a break with tradition. So that's what can happen when the moral rights last forever. In India as well, from 1957, when India first got its Copyright Act, right up until 1994, you had perpetual protection for moral rights. It changed in 1994 because the government became afraid that it would then be responsible for recognizing moral rights in the works of authors who were long dead. And when we get to India, you'll see exactly how that played out in practice. If I click on this, will this get me to the internet? Okay, well, let's try and see. So I thought we could start our global survey with the UK, which is sort of the mother of all common law systems. And
burning, 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 burning. Do fifth gear in a fire engine. Ting-a-ling-a-ling, while alarm bell ring, but you can't put out the fire.
This is what the case was about.
Burning, burning, burning. Do fifth gear in a fire engine. Ting-a-ling-a-ling, alarm bell ring. You can't put out the fire.
I don't know if you can tell, but the speaker is actually inventing some words to make the rhythm of the speech go along. That was actually a key material fact in the case. I didn't plan to make you listen to the whole thing. There we go. Okay. So, as you can see, it was a case about, I guess you could call it rap music or hip-hop. So we have the hip moral rights in the UK. It's a song called Burnin, as you probably gathered. And it was composed by a person named Andrew Alsey, who sold that composition to a group called Confetti Records. Now, Confetti was a small label specializing in something called UK garage or speed garage music. You probably know more about this than I do. But what Confetti did was it hired a group called the Ant Ill Mob to record it. And this was what's known as a concept group in the music business. So it had no permanent members. It was just session musicians who gathered together, formed this group, and made the recording. Song turned out to be successful and actually rose to the #1 spot on the UK Garage Top 10 list. When that happened, it was noticed by the Heartless Crew, a UK garage group, who wanted to record the song in their own cover, their own version. And they did so in the format and under the title Crisp Biscuit. So it's the name of both the album and the technique, the sort of layering of different sounds that gives it that particular feel. The case actually is a contract case because in the process of trying to obtain the license for the song, the Heartless Crew got into a number of mishaps. But we'll leave that aside given the brevity of the time, and I'll just talk about how moral rights under the Copyright Designs and Patents Act of 1988 arose. So basically, moral rights became an issue because Andrew Elsey, the original composer, said that the remixed version of the song included references to drugs and violence, to which he objected. So if we look at the relevant section, Section 80 of the CDPA, the Protection of the Integrity Right, the legal question became very interesting. Whether this section could be broadened beyond a reputation interest. What do I mean by that? Well, the language says the treatment of a work is derogatory if it amounts to distortion or mutilation of the work or is otherwise prejudicial to the honor or reputation of the author or director. And what the plaintiff's lawyer tried to do was to split that last clause off from the rest of the provision. So a distortion might be a violation of the right of integrity, a mutilation might be such a violation, or some other act that's prejudicial to the honor of the author might be a violation of the right of integrity. So could this mean that any mutilation or distortion violated your right of integrity, or did you have to prove damage to reputation became the key question? And of course, if that question had been answered in the affirmative, it would have taken the British moral rights scheme, very conservative and carefully drafted as it was, and transformed it into a French-style open-ended protection for moral rights. So the judge in the case, not surprisingly, did not buy that argument. He said that it just had to do with the way the section was written. It was the compressed drafting style of the UK legislature that was behind the construction of that phrase. Nevertheless, the court had a great deal of difficulty even in dealing with the pared down version of the integrity right contained in the Act, because it couldn't quite assess the issue of damage to reputation on which the whole thing turned. The reason for that being that it was hard to assess what the song actually said. In particular, the use of special words and sounds by the rapper was noted by Justice Lewinson, who said, "This complaint led to the surreal experience of three gentlemen in horsehair wigs examining the meaning of such phrases as mish mish man and shizzle my nizzle." So the court said the problem in understanding the words militated against a finding of an integrity violation. Now, could they have called in expert evidence? There too, the court felt limited, because it felt that only drug dealers would know what was needed to know in this case. And Justice Lewison comments, the occasions on which a drug dealer might be called to give evidence in the Chancery Division are likely to be rare. I think they could have called police witnesses, but anyway, this was his view. And they also attempted to use a dictionary, an online urban dictionary from the internet, to help them to figure out what those words actually meant. And there was another factor that came into play too, a more practical one, which was that the Anthill Mob in their original recording appeared in gangster-style outfits. And so the question became, why did Elsey not object to that particular manifestation of violence in the preparation of the composition? Now, given the way in which the plaintiff's lawyer had framed the claim, no evidence was offered on the reputation issue. The plaintiff's lawyer was hoping that he or she wouldn't have to. And so the judges were stuck as far as reputation went. What was Elsey's reputation? How did or could the remix affect it? They had no answers to these questions. And so, of course, the case failed. Perhaps it's a bit of an opportunity missed because it did have this interesting undercurrent of a chance for artists to take some moral or social responsibility for something that they create. And I don't know how significant the costume issue really was. I don't know how significant the issue of finding expert testimony on the drug side of things was either. But I'll leave you to develop your own opinions about that. Canada is an interesting case because we, of course, have this historic mixture of French and English traditions, which also applies to some extent in the area of copyright. We do have continental and British traditions of law. And sure enough, Canada was the very first common law country to enact moral rights of the author. We did that in 1931, just 3 years after they were first enacted in the Berne Convention. So we were as always, I think, like to think, good international citizens in this regard. But I'm afraid the good news on Canadian implementation of moral rights stops there, because in the entire history of these provisions, as I mentioned earlier, there has really only been one clear success in terms of litigation. So there's great practical ambivalence about moral rights, including the fact that standard form blanket waivers of those rights are the norm in authors and artists' contracts in Canada. The successful case relates to the picture on the screen. That's actually a sculpture called Flight Stop by a gentleman called Michael Snow, and it decorates the Toronto Eaton Centre, probably Canada's most celebrated shopping centre. And one Christmas time, the owners and administrators of the shopping center got into the festive spirit and decided that they would decorate this sculpture with some festive ribbons, and other cheerful sorts of seasonal decorations. And the sculptor was quite upset by this, felt that it destroyed the artistic integrity of his creation, and he sued. And in that case, in which he was successful, he called experts from the art community to talk about how indeed his artistic reputation was likely to be damaged by the association with the decorated version of his work. The judge was persuaded, and the order, of course, was to remove the ribbons forthwith. Now, though, we're seeing a very interesting legal movement in Canada, which is more interest in the area of moral rights, more litigation, reaching now up to the Supreme Court level, and a problematic issue, a split at the Supreme Court between English and French judges. And the legal issue on which all of this is turning seems quite arcane at first. It has to do with the relationship between economic and moral rights. And basically the question is, are they two sides of the same coin, or are they two distinct families of rights on their own? And there are actually two names for these schools of theory, one being the monist approach, which is two sides of the same coin, the other being dualist, which is the split between the two branches. And again, it seems like a fine point of theory, but it has very important practical implications. So in France, the way that we get perpetual protection for moral rights is through a dualist system, because economic copyright has to be time-limited, but the moral rights are potentially free form, and so they're allowed to persist forever within the French copyright law. So duration is affected by that theoretical point. Now, legal systems may not always be entirely clear about the doctrinal basis of their protection for moral rights. They might have a hybrid or mixed system. That's somewhat the case in both India and Russia, as hopefully we will see. But in Canada, what we really have is confusion. And the confusion has turned on this particular issue. Do we have a monist or a dualist approach in our legislation? Or, alternatively, but we haven't quite got there yet, eventually, do we want to forge a mixed approach? Now, we do have a monist system in the sense that duration of moral rights is limited, so it lasts as long as copyright and no longer. But in a 2002 Supreme Court case called Théberge versus Galerie d'Art du Petit Champlain, the Supreme Court seemed to reject this monist theory. When it did so, it took the existing dualist theory and turned it completely topsy-turvy. So, as I've already suggested, the traditional meaning of dualism is more extensive protection for moral rights than for economic rights, because it's a natural rights theory. But in Canada, when we espouse a dualist theory, we mean that we give less protection to moral rights than to economic rights. And then to confuse matters further, in 2003, the Supreme Court had another ruling, and it made an off-the-cuff remark that actually Canada is governed by monist theory. So what happened in Théberge that gave rise to this debate? The case had to do with reproduction of an artwork. And what essentially happened was Claude Théberge is an artist, a painter, who authorized the making of a number of souvenir items associated with his work, so postcards and other works of that kind that would reproduce his original images for the purpose of souvenir sales. And what eventually happened was that another company came along and decided to make canvas-backed reproductions of his work. What they did was to take a postcard, lift the ink from the postcard, and superimpose that image upon a canvas. So note that in this process, there's only one copy of the work at any given point in time. Okay, the postcard exists at the beginning, the canvas is blank. At the end, the canvas bears the image, the postcard is blank. Believe it or not, that is actually the key factual issue on which the decision turns. So the artist actually gave evidence that he wasn't especially concerned about the commercial consequences of these new canvas-backed reproductions. What he was worried about was his reputation. And he felt, presumably, that people would be confused when they saw those canvas-backed works and think possibly that they were original works by him. When the Supreme Court considered the case, it came back and said, the majority, I should say, said that no reproduction had occurred. The reason being that there was one copy at the beginning, one copy at the end, and that multiplication of copies is really what defines reproduction. One of our outstanding judges actually gave that judgment, Justice Binney of the Supreme Court of Canada. What he said was that Theberge was doing something a little bit underhanded. He was trying to make a moral rights claim about his reputation while framing it as an economic rights complaint. And Justice Binney said, well, you can't do that because there's a different standard of proof that applies to moral rights claims. You know, when it comes to copyright, any unauthorized act by definition is a violation of copyright. But as we've just seen in those few examples, when it comes to moral rights, usually you have to prove that there has been some damage to your reputation before you have a right to complain. And so Justice Binney said we have to be very careful. We have to protect that extra standard of proof when it comes to moral rights in Canada. The dissent for all of the French judges on the court, written by Justice Gontier, he said, well, this is not a case about moral rights. Reproduction has occurred, and what matters is not the number of copies that exist, but the number of times the transformation of that particular work occurs. Again, here, clearly, there have been two attempts to create copies of the work, so clearly it's a case of copyright infringement. He says what we must count in order to determine whether a work has been reproduced is not the total number of copies in the work, but the number of materializations that occurred over time. Split, English judges for the majority, a victory of one, all of the Francophone judges on the minority. So it just remains to be seen how influential that decision is actually going to be, whether the majority or the minority view persists in the future. Let's turn to India, which I think will be the conclusion of my remarks today. Sorry, we don't have time to get to Russia because it's a fascinating example of moral rights also, but perhaps in the questions if we have time for those. In India, we had a leading moral rights case in 2005, and that case turned on the issue of how to recognize a copyright work as an important part of a nation's cultural heritage. And you can think of it as a sort of life cycle question. It's a distinction between intellectual property and what eventually becomes cultural property. So something might be created at some point in time. At that point in time, it's a work of individual authorship or group authorship potentially. It's a work created by identifiable authors. And that is the definition of a copyright work. When the author dies, a transitional movement is initiated. So it continues to be intellectual property for a period of time for the duration of copyright protection, 50 or 70 years after the death of the author. But there's no living author to take care of it, so it's in charge of the heirs or whoever has inherited the rights of action. Finally, after the term of copyright protection expires, the work falls into the public domain. And at that point, it becomes cultural property. So its connection with the specific author will be more remote. But on the other hand, as the judges in this case pointed out, its connection with a community or a country may be stronger than ever. We have different legal frameworks governing cultural property and intellectual property. Intellectual property, private rights, private property rights. On the other hand, cultural property, it's a framework of public international law conventions. So a completely different legal theoretical framework for both forms of rights with, as usual, practical implications. In the case of Amarnath Segal versus Union of India, Mr. Segal, seen in this picture with then Prime Minister Nehru, was a sculptor of great national and international renown, and he was asked to design a sculpture for a public building in New Delhi at a time when Nehru wanted to encourage Indian artists to showcase the culture and revive the pride of the country after the colonial occupation. And in fact, here we see the sculptor visiting the actual work of art when it's been placed on the wall, that mural in the background with Pandit Nehru. So he completed the work in 1957 for the august sum of 300 rupees. But the work came to be considered a national treasure of India. But in 1979, the mural was actually taken down by the government of India for the purpose of storage. And when they did so, they damaged it because of improper transportation and storage. Segal, very upset about this, so he applied for an injunction to prevent further damage, which was granted in 1992. That shows you how the Indian legal system works. Okay, and eventually in 2005, so some nearly 30 years after the litigation was first brought, he won damages in the case. But what happened between 1992 and 2005? Well, the Indian government decided that a reform of moral rights was due. This is because the original scheme from 1957, as I alluded to earlier, contained a very broad statement of the moral right of integrity. It said that there was no requirement for damage to reputation, and there was no specified duration, leading to the possibility that moral rights in India could last forever. And sure enough, in the interim ruling, the court had a very sympathetic view of the author's situation, and it imposed a duty of care on the Indian government to deal with works in its custody. The Indian government, I think, became very nervous about this ruling and introduced amendments which came into effect in 1994. Those amendments redrafted the integrity right to match the limited formula in the Berne Convention, where author's reputation was required, and it also created limited duration for the protection of moral rights. So how did the judge address all of these issues in 2005? He had a few choices. He could have said, for example, that the old provisions continue to apply because the damage occurred at a time when they were in force and because that was when the suit was brought. Or he could have said that the new provisions apply because clearly there was a change in policy that was intentional on the part of the Indian government. Now, in the event, as judges do, he did something completely different. He made 2 points. The first was that it didn't really matter in this case whether we took the old or the new versions of the provision, because destruction of a work of art, which is what was at issue here, does affect the reputation of the artist. It damages his overall creative corpus. So the idea of destruction was affirmed by the judge as part of what is covered by the right of integrity. And he then goes on to say that in the case of outstanding works of art, it's not only the intellectual property framework that applies, but it's also the cultural property framework that applies. So there's an overriding obligation derived from cultural property principles to protect the integrity of the work. And to go back to my point, it doesn't really matter whether it was the old or the new provisions, because the cultural property obligations of India require us to read those provisions as if they were the old ones, to put it in a very lawyerly framework. And so he says, the various declarations by the international community in the cultural property conventions noted above lift the moral rights in works of art if the same acquire the status of cultural heritage of a nation. India is a signatory to the conventions, and it would be the obligation of the state to honor its declarations. So in other words, interpretation of the moral right is colored by the recognition of cultural property belonging in this case to the nation or the country. And that has to be the context in which any legal provisions on moral rights are interpreted in India. So unfortunately, we don't really have time to go into Russia, but as I said, there are many interesting things to discover in the experience of Russia and other post-socialist countries about the relationship between copyright, moral rights, and free speech. I will just conclude by remarking that I hope this quick survey has helped everyone to see that difficulties in implementing moral rights are not unique to the United States by any means. These are difficulties that are faced by common law countries everywhere, even in a context as culturally removed as that of India. But I hope you're also persuaded that recognition of moral rights in such a variety of jurisdictions is a persuasive argument that they're worth looking into. And the goals that are pursued through moral rights in those environments do reflect interests that are likely to grow in importance in the digital age. Concerns such as the preservation of cultural heritage in the case of India, historical truth and the human rights of creators in the case of Russia and post-socialist countries. I think that given the exceptional democratic heritage of the United States, these are worthy goals to pursue through the US copyright and moral rights provisions. So thank you very much for your patience.
And I hope you're also persuaded to go out and buy her book, which she's plugging back here very, very subtly. In the interests of time, I think we won't do a Q&A session here, but we do have a reception just outside for anyone who'd like to stay and ask Mira questions about Russia or about her presentation. You're all welcome, and we'd love to see you around there in a few minutes. Thank you all for coming, and thank you very much, of course, for presenting. Okay.